We have made this video because we receive a lot of inquiries from clients about changing a child's surname. So can you change your child's surname? If you want to change your child's surname, you need the consent of each person with parental responsibility in order to change the surname of a child who is aged 16 and under. In most cases, the mother of children has parental responsibility at birth. A father who was married to the mother at the time of birth or is named as father on the birth certificate will have parental responsibility. If a father is not named on the birth certificate at birth, then a father can acquire parental responsibility by a court order or by consent. So it's important, if you want to change a child's surname, to work out who has parental responsibility and who do you need consent from. Now, if, for example, a mother wants to change a surname, even if a father doesn't have parental responsibility, it would be best practice to try and obtain the consent of that father. So if you want to change a child's surname, it's not whether the child wants to change their surname, it's whether those with parental responsibility consent. Now, if everybody consents, that's not a problem. What if a person with parental responsibility will not consent to a change of a child's name? An application can be made to the family court for what is known as a specific issue order. And that application should be made if a person with parental responsibility will not consent to the change of name. Now, if somebody makes an application to court for a court order that a child's surname can be changed, that person needs to show the court that it would be in the child's best interest for this order to be granted. It's not simply that the child wants to change the surname, or that, for example, maybe the child hasn't had much contact with the father for some time. It needs to be in the child's best interest. A child's name is very much part of who they are. If you want to change your child's surname, you need to remember that the courts are very reluctant to change a child's surname, particularly if one of the parents with parental responsibility opposes the change. Some people have tried to get round this by asking that the child is known as a surname rather than formally changing the surname. That should not happen. A child has a name, a surname on their birth certificate, and that is the name of the child unless either everybody with parental responsibility consents to a change or a court makes an order. Simply being known by a completely different name should not happen. So what if you want to change your child's surname and those with parental responsibility do not consent? You need to complete a form known as a C100. And when you complete the C100, you need to make it clear on the form that a specific issue is sought permitting the change of a child's surname. It is only if the court make a specific issue order permitting the change of a child's surname that a child's surname can be changed. And as I've said before, do remember that courts are reluctant to make such orders. What if the whereabouts of one of the people with parental responsibility is not known? An application to court should still be made for a specific issue order permitting the change in the child's surname. If you're making the application, you will need to demonstrate to the court that every effort has been made to locate and communicate the application to the person with parental responsibility. You will need to show that you have contacted the parent's last known address, all known relatives, the last place of work, and anywhere else where that person might be. So you will need to show a lot of evidence that you have made every effort possible to try and locate that other person with parental responsibility to see if they will consent to a change of surname. Please remember that the courts have previously taken the view in other cases that if a child does not have contact, direct contact to a person with parental responsibility, such as a father, then it's even more reason for the child to keep the surname of the biological father, because that is the only link that child has to the father. So simply because a child does not have contact to the father is not good grounds to change your child's surname. The courts certainly are unlikely to accept that as good grounds. Please remember that you need to show exceptional circumstances to change a child's surname. So, for example, it might be that the child has the surname of a notorious criminal or someone who's been in the news and is perhaps not seen in a good light. It will really be the exceptional circumstances, the exceptional cases where the courts will consent to a change of a child's surname. I can only recall about 2 cases in 30 years where the courts have granted permission for a change of surname. So do remember, it's going to be exceptional. Now, when making the application to court, it is important when completing the C100 form to include details of why a change of surname would benefit the child. The fact that a child wishes to change their name or has had no contact with the person with parental responsibility for some years is unlikely to be a good enough reason. When making an application to court to change or vary a child's surname, a court fee is also payable. However, if you're on a low income, you can complete what is known as a fees exemption form, and you may be exempt from paying the fee. What factors will a court take into account when deciding whether to make a specific issue order? When deciding whether to make an order, the court will take into account Section 8 orders under the Children Act, which are as follows. The wishes and feelings of the child concerned, considered in the light of his or her age and understanding, his or her physical, emotional, and educational needs, the likely effect on the child of any change in his circumstances, the child's age, sex, background, and any characteristics of his or her which the court consider relevant, any harm which the child has suffered or is at risk of suffering, how capable each parent and any other relevant person is of meeting his needs. So when you're completing the C100, have what we call the welfare checklist in mind and try and see if you can apply any of those factors to the reasons why you want to change the child's surname. It might be that you would say the child is at risk of suffering emotional harm if the surname isn't changed because that's what the child wants. Try and apply this welfare checklist. Not all of the factors will apply in your case, but some of them will. If you're wanting to change a child's surname, it is likely to be beneficial to try and seek some independent legal advice.